I was actually reading Shashikant's judgment, and that is 2002, volume 5, S7. And my submission was that I was,
You are almost concluded reading that.
yes,
You are submitting that the observations therein are not correct in law
but my
with regard to mandatory and direct.
my submission on that is that so far as it holds the 3191 part to be directory, that in my respectful submission is not correct. 3191 is the material provision,
And the rest of them are procedural.
yes, the rest of the three are procedures as to how it is to proceed. Is my first submission regarding Shashikant. My second submission regarding Shashikant is, in any case, Shashikant is a case where the 319 order was passed at the correct time. And that is how the reference order has also distinguished Shashikant. But anyway, that's not binding, or that's neither here nor there. So therefore, according to me, Shashikant was a case where the order had been passed at the correct time. And therefore, Shashikant is entirely different on facts. Now, Shashikant has been relied 2 times thereafter. Both judgments are in the learned solicitor's compilation. I'll refer to them at a later stage just now. There is no further discussion on what Shashikant holds. Shashikant's principle has been picked up and applied twice again. First, it has been applied in 2002, volume 5, SCC 738. If your lordship feels your lordship can just, it has been applied in 2007, volume 7, SCC 378. I'll refer to these 2 judgments a little later, my lord. Let me first. So my second submission on Shashikant is that it is entirely different on facts. There the order was passed within time. Then, my lord, we come back to interpreting 3191 itself. Now, on that, my lord, I have just a small compilation. There is the Law Commission's report on the basis of which the provision itself was introduced. Your lordship may kindly have that report of the Law Commission. Where is the page? Needing the paging. That is at page. Well, this is only the Law Commission's report and 3-4 judgments where the same principle I'm saying has been. Just kindly have the last page 53 onwards of what the Law Commission says, my lord. At 54. 53 at 54. This is the 41st Law Commission report, on which basis section 351, which was earlier there, was amended and renumbered in the new code as 319. Now, the reason why I'm reading it is, this also says you can join him in an ongoing trial, not after the trial is over. The whole purpose of amending this section and introducing it as per the Law Commission was to enable the person to join in an ongoing trial. And therefore, Hardeep Singh is absolutely right in its conclusions, is my respectful submission. And my lord, I would rather say the principle in Shashikant, it does not even arise for your lordship's consideration, because Shashikant is a case where 3191 was passed at the correct time. Now, kindly have this bottom of page 54, my lord.
But earlier, 319 was amended, or it should unamended? Has it been amended?
Yes, 351 was altered slightly. And
that is prior to the 73 Act. CRP
no, under the 89 code, old code.
89.
Yeah.
So it was an amendment. Actually.
No. It is reintroduced in its present form after making the modifications which the Law Commission has suggested. Once your lordship reads this, the lord.
What are the pre-amended positions?
My lord, pre-amended.
55 is pre-amended.
Yes, there were only persons attending trial who could be joined.
Can we have that?
Yes, I'll just get it. Only a person who was actually attending. Once I read this 24.8, it will become clear. This explains the previous position and the new position. Let me read page 54 at the bottom. Okay. So, your lordship may have Hardeep Singh at 113. It quotes the earlier provisions. Hardeep Singh quotes it at page 113.
Correct.
Yes. If your lordship will have the judgment in Hardeep Singh, that is,
In the compilation, what is the page?
but in this compilation,
Page 22.
it is at page 1 of the compilation given by the,
Page 22.
Page,
internal-
internal page 22. of the
Yes.
compilation.
yes, internal page 22.
What para, Patwale, any idea?
Para 10,
Ah.
para 10,
Yes.
para 10. In order to answer the aforesaid questions posed, it will be appropriate to refer to section 351 of the Criminal Procedure Code, where an analogous provision existed, empowered the court to summon any person other than the accused if he is found to be connected with the commission of the offense. However, when the new CRPC was being drafted, regard was had to the 41st report of the Law Commission, wherein paras 24.80 and 24.81 recommendations were made to make this provision more comprehensive. The said recommendations read: the 351 limited to this is the same recommendation actually.
This is the same recommendation.
Yes, this is what I'm.
Extract from that, those.
Yes. I can read it from there, but it was limited to offenders in court. Section 351 limited to offenders in court. But then let me read it from page 53 because the complete thing is there. 24.80 is reproduced. Let me read it from page 53. It's better. It's completely reproduced for us. Yes, page 54 at the bottom. It happens sometimes, though not very often, that a magistrate hearing a case against certain accused finds from the evidence that some person other than the accused before him is also connected in that very offense or in a connected offense. It is only proper that the magistrate should have the power to call and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceeded against. There is no express provision in section 351 for summoning such a person if he is not present in court. Such a provision would make section 351 fairly comprehensive, and we think it proper to expressly provide for that situation. Section 351 assumes that the magistrate proceeding under it has the power of taking cognizance of the new case. It does not, however, say in what manner cognizance is taken by the magistrate. The mode of taking cognizance are mentioned in section 190 and are apparently exhaustive. The question is whether against the newly added accused, cognizance will be supposed to have taken on the magistrate's own information under section 191C or only in the manner in which cognizance was first taken of the offense against the other accused. In concrete terms, if the original case was instituted on a police report, that is under 191B, will cognizance against the new accused be supposed to have been taken in the same manner as under section 191C? The question is important because the methods of inquiry and trial in the two cases differ. About the true position under the existing law, there has been difference of opinion, and we think it should be made clear. It seems to us that the main purpose of this particular provision is that the whole case against all known suspects should proceed with expeditiously, and convenience requires that cognizance against the newly added accused should be taken in the same manner as against the other accused. We therefore propose to recast section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if the new person is added as an accused during proceedings. Please note, this is of course necessary as already is provided that in such a situation, evidence must be reheard in the presence of the newly added accused. The offense for which the newly added accused can be tried is not indicated in precise terms in the section. Obviously, the offense should be connected with the one for which the original accused is under trial, also present tense. To bring that out, a small verbal amendment is recommended. Section 351 should therefore be amended as follows, and then that 319 as it stands today is reproduced. And at page 57, ultimately, it is accepted by the Rajya Sabha. Page 57 at the top, second column, top right, it's clause 198 to 319 were added to the bill. So 319 is added by the Rajya Sabha. So we have three parts. I've already highlighted at the top of the page, in the fourth line, it is only proper that magistrate should have the power to call and join him in the proceedings. So the proceedings have to be live. Second, I have already said in the lower half of para 25.81, during the proceedings. And the third is when the proceeding is under trial. So therefore, my lord, that is how ultimately my lord, 319 as it stands, for the proceedings to be live, it is very important. And therefore, what Hardeep Singh holds is absolutely correct. And Shashikant doesn't take that away, because Shashikant is a judgment where 319 was passed in time. And your lordship was faced with a situation where, because of the person added going to court and getting an injunction, etc., the proceedings could not continue. And therefore, your lordships found a via media that he should not be allowed to take advantage of his own wrong. Now, my lord, I have given in this compilation that I have just given to your lordships some judgments, my lord, where Hardeep Singh has been followed by your lordships, and some judgments of high courts only as a persuasive value, my lord, where your lordships will see where various high courts have taken the same view before and after. And if your lordship will have this compilation at page 1 is the judgment, my lord, of 2017 7 SCC 706. And I must say there is no added discussion. It's just Hardeep Singh has been followed. I mean, so far as the two judgments of your lordships are concerned, Hardeep Singh has been followed. And the first judge, your lordship may kindly have at page 8, para 10 of Brijinder Singh. Para 10 at page 8 says, it also goes without saying that section 319, which is an enabling provision, empowering the court to take appropriate steps for proceeding against any person not being accused, can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of 207, 208, etc. Then para 11, my lord, is the further what Hardeep Singh says, what is the evidence? And para 12, what is the degree of satisfaction required? Again, I am not actually going into all that, because then your lordships have said that your lordship
beyond the reference.
Yes, your lordship will be sending it back. Though the third question referred is, I'll read that. That I submit is completely covered by the rest of Hardeep Singh. I'll come to the third question, my lord. So this is one judgment where Hardeep Singh is followed. Then, my lord, another judgment where Hardeep Singh is followed is at page 35 in 2021 itself. Yes. At page 35, if your lordship will see, that is not reported in SCC. So I have the SCC online citation for your lordships at page 35. Now, again, the page 40, para 33, when the discussion starts, Hardeep Singh is considered. Para 33. While considering the rival submissions, the law on the scope and ambit of 319 is required to be considered. In the recent decision in the case of Sartaj Singh, this very bench has considered in detail the law on the scope and ambit of 319. In the said decision, this court considered the decisions of Hardeep Singh, Mohammad Ispahi, Rajesh, etc. Then, my lord, that decision is quoted extensively here. And after quoting it extensively, right up to page 48, then para 34, the ratio is laid down by the court. At page 48, para 34. It again follows Hardeep. And perhaps it would have to, because it's a two-judge bench and Hardeep is 5. So it would. The ratio of the decisions, para 34, on the scope and ambit of the powers of the court can be summarized as under. At page 49, clause 9. Again, my lord, after charge sheet is filed and before the pronouncement of judgment, except though it's the same, Now, my lord, some judgments of different courts, my lord, where similar view is taken. High courts, if your lordship wants, I can just quickly take your lordship through, or I have attached 5 or 6 of them, my lord, where there are all single benches of the high courts, my lord, where 3 or 4 of them are before Hardeep Singh, also take the same view on a plain interpretation of 319. And the others are after Hardeep Singh, and if they are after, then naturally, my lord, they will have no option but to follow Hardeep Singh. So, my lord, my therefore respectful submission is that so far as 319 is concerned, the provision of the section itself is crystal clear, my lord. I have labored yesterday enough on it. I did not again labor on that, my lord. And it is conditional at the cost of, my lord, extreme repetition, my lord. I just 3191, where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being an accused has committed offence for which such person could be tried together with the accused. So that's the crucial part, together with the accused, and therefore the court has the power. Also, my lord, this section appears in that part of the code, which is chapter 24, which deals with general provisions as to inquiries and trials. That's the placing of the section. It is placed in the part of the code which regulates how inquiry and trial is to proceed. So if the trial itself is over, then there is no question of exercising power under 3192. And that I have said, when it is fixed for pronouncement of judgment, and after judgment, the court becomes functus officio. So that is one part. Now, my lord, I need to clarify one more functus thing, lord. And that is, lord, the order by which the trial was separated. Kindly have that order, my lord, dated 28 September 2017. It is at page 537 of volume 2 of the additional document.
Statement what you read also is that after trial and before pronouncement also it can be done. 362 was after judgment, no review, no change except clerical errors. But now, I mean, just to put the matter in our case, it may not arise because 3110 was the date when it was posted for judgment, judgment was pronounced. Let us say in a case, trial is complete, arguments are heard, the matter is posted for judgment. Because the provision 319, what you say is also is the power of the court to find out whether somebody has been left out deliberately to include that section. While assessing the evidence, the judge finds that somebody else should have been. At that stage, he does not pronounce the judgment. He says for further hearing.
Correct.
At
So
that,
trial revives.
it revives. So at that stage, it can be done.
Correct.
Just to put the matter.
So I was also, because there was a hiatus between posting the matter for judgment and pronouncement of judgment.
Correct.
So we were also discussing yesterday, and I would have said it a little later, that what happens if when the judge is sieving through the judgment and he finds that actually this man is
Correct.
it should be the main person who should be there. Then, my lord, according to me, he would post it for hearing, and then he would pass an order under 319, and thereafter proceed accordingly. That kind of a situation has occurred in a judgment, my lord, which is actually a one-pager. It is
Patwalia, just 1 second. 1 second. See, the language employed in 353 is 353.
yes,
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in the open court by the presiding officer immediately after termination of the trial.
or at some
But
subsequent.
that's all right. Supposing immediately he pronounces.
Then we are in my situation. Then according to me, he cannot do it.
No, he has an option to immediately pronounce. No,
Correct.
what I mean is, my brother asked a question. Now, does it make any difference at all? Because if he immediately pronounces or he pronounces on a future date. So once the hearing is complete and once it is posted for judgment, the only thing he can do is he has to pass a judgment this way or that way on the same day or on a future date after reserving the matter. Just to throw some light on this.
So on that one, what my submission is, if he passes the judgment, the crucial point is when he passes the judgment, because trial is over when he fixes it for judgment. Then we are in a situation where trial is over, but there is no judgment. So the court really is not functus officio. The court is still in session of the sessions case. This case will show, it's very interesting. But first, let me complete this. Then I'll tell your lordship how this case will show this problem. So he is still in session of the trial. So at that point of time, he has two options. If he has not pronounced judgment on the same day when he has closed the trial, he can then repost the trial for hearing. And if he reposts the trial for hearing, he can pass an order under 319, or he can pass a judgment. But according, in my respectful submission, the moment he passes a judgment, he in any case becomes functus officio. Then he cannot pass 319. Why? It has happened in this case, and that's why I'm showing these orders. What the learned judge does in this case, on 28 September 2017, he passes an order separating the 319 application and saying, I will continue with the trial. This I am separating. Now, when he separates it, in what trial is that application? So he numbers it as a miscellaneous application in no trial. So he says it will be numbered as a miscellaneous application. He has no power to entertain such a miscellaneous application. I'm going to read those orders just now. When the trial is over, he passes the judgment in trial number so-and-so of 2015. But on that, then when he sits to decide the application, that trial is already over. So the order in the application is passed in a miscellaneous application number so-and-so. It is the procedure and the existence of the application is unknown to law. And this case is a very good example of that situation. Now, therefore, that's what I'm going to show to your lordships just now. Now, kindly have this order at page 537, where he separates the application from the trial, and then what happens as a consequence of that.
It's in which volume?
It's in volume 3, my lord, volume 2 of those additional documents. It's a thickish volume, yes.
And we can do that.
What page, Patwalia?
537, 537.
That's if we can.
Yes, we have.
Now, kindly see at the top. It is ND, my lord, is the narcotic drugs. The trial number is 289 of 2015. Now, this order he passes. The case is at the stage of filing reply to the application under section 319 CRPC. Today, reply is filed. Perusal of the file shows the case pertains to the year 2015. 10 accused are facing trial in this case. Out of 10, 2 are on bail. Remaining 8 are in custody. The prosecution has examined all required witnesses. Further, the High Court has time-bound this case with a direction to complete the trial till 8th November 2017. And today is 28th September 2017. So because of application under section 319, trial will take further time. Present accused will suffer without any fault of them. So Elmad is directed to separate the application under 319 and register this application as a criminal miscellaneous. This cannot be done. For separating present trial and application under 319. So he separates the trial from the application from the trial.
What is it? What is it? So Almat is some post there.
Elmad is the court reader, my lord. It's below the reader. The Elmad is, there is a reader and then there is an Elmad. The custodian of the record, yes, so to say.
I thought there is somebody called Ahmad. So he directed Ahmad.
No. The restorer blood who keeps the files. It's a restorer who keeps the files. Blood. He's called
No,
Al.
record keeper.
Yes.
He's given a bigger degree than a clerk.
This
Alma.
is not a Punjabi word.
Correct.
Urdu.
He's a powerful man in the court.
In fact, most powerful person.
In commas. So
Somebody like a sheriff, we call it, is it? No.
No, my lord.
Solicitor is court reader.
He's court reader. My lord. In fact, he's the custodian of entire files of the
Yes,
court.
yes.
My lord, in fact, he is having the key of the Almira where the files are kept. So he's the most powerful person in the court.
he issues notices, summons, everything. Almas is doing.
No,
All right, yes.
So, my lord, just see. So, this order is completely illegal in my respectful submission. I am not a party at that point of time. I did not challenge it.
No,
But
here in this case, this one trial in the main case has not been concluded.
Not on this date. No.
In this case,
Yes,
particular case.
yes, not on this date. No, in this case, trial is complete. Today it is complete. On the day when the order is.
In this, the judgment you read, some application is filed during the trial.
Correct. This very case. I'm reading this very judgment.
What he does, he separates his application and decides. to-
Where is the order passed on this application?
I'm coming to that. I'll just give me 2 more minutes.
So
I'll read it.
that is passed on the same day.
No, that is passed later. That ultimately judgment is of 31st October and order will also be passed on
On
31st.
the same day.
Yes, same day. After, I'll read the judgment
And what
and
is
the
the
order.
Only one submission, my lord. In fact, the Honorable High Court had ordered that the trial be expedited. So
Correct.
the trial, only, I'm just giving the reason for bifurcation.
That reason is already reflected.
Yes, that is there in the order.
He has already read that.
Yes,
Yes, right.
that is the reason.
So,
The reply is filed by whom? To this application?
the other accused, he issues notice in this application to all the other accused.
Not to you.
No. If your lordship will have page 536.
Well, as proposed accused, he is not summoned, he cannot appear, he cannot.
We are aware about that. There is a judgment by Justice Bobde.
Yes.
Yes, which says that he should be given notice.
No,
He should
proposed
not be given
accused
notice.
cannot be.
There is a judgment by Justice Bobde which says that a notice is not necessary.
Not because he is a proposed accused, he cannot be like
I
156.3.
will cite that.
Like 156.3, my lord, he can't.
I will cite that where it says notice should be given. But anyway, I'm not on that. That is neither here nor there. My lord. We are far beyond that stage today. So 536 he gives he gives notice to the other accused. If your lordship will see the earlier order of 21st September, he says prosecution has filed an application. This is the first day when the application comes up. Where the order is at page 536. 1 page before. 21st September, the application is filed. So it is the first day it comes up. Prosecution has filed an application under section 319 CRPC. The other accused requested to give opportunity to file reply. Accordingly, the case is fixed for 28th September for filing reply. So on the second date itself, he then passes this order. Now, the second part of the order is equally interesting, my lord. I have read. So the Almad is directed to separate the application under 319 and register this as a criminal miscellaneous is unknown to law. It is doing violence to 319. He cannot separate it. The application is integral to that trial.
Let us read further.
Yes.
For separating.
For separating present trial and application under 319 CRPC, I rely on 1999 1 RCR Criminal 283. There is no judgment on this page. I have done my research. If I am wrong, my lord, the Learned Advocate General's office can find out. This citation is wrong. There is no judgment on 1999 1 RCR Criminal 283. There is no such judgment. But in any case, I think probably either the page is wrong or the year is wrong. We have tried to do 10 pages up, 10 pages down. Also, nothing could be found. So probably the year may be wrong, Lord. That was too much of, I do not know which judgment he's relying. Now, where our own Honorable Punjab and Haryana High Court has held, one of the accused went abroad, not available, trial lingering, trial court directed to take appropriate action for splitting case. In any case, what he's relying on is totally different. That is not a 319 case where an accused is abroad. There, my lord, 3172 gives power to him to separate trial, and therefore that power can only be exercised in case of a person facing inquiry or trial. So therefore, this whole concept of separating trial in 319 is unknown to law. It cannot be done. I'll show 3172 also. So for separating present trial and application under 319, I rely upon 1999 1 RCR Criminal 283, where our own High Court held one of the accused went abroad, not available, trial lingering on. High Court directed to take action for splitting the case. Further, as already discussed above, this case pertains to 2015. 10 accused are facing trial. 2 are on bail, remaining are in custody. Let APP request for adjournment for prosecution evidence. My mind, prosecution has sufficient opportunity. So I need not read the rest of it. The next steno of this court is directed to print 2 copies of this order. One is to be placed on this file, and this file is fixed for recording statement of accused under 313. Other copy is to be placed on criminal miscellaneous file, and criminal miscellaneous file is fixed for consideration of application under 319, which is fixed for 4th October, etc. So he separates it, which according to me, he cannot do. It's completely illegal, this order. Then what he does, he decides the main case. Now kindly see the judgment in the main case. I just want to show the index and then one para of the judgment, because yesterday I said this application is not mentioned. I stand corrected. It is mentioned. So that is, judgment is in volume 3, R3, this very. Kindly have this volume, just have the very first page of the judgment. The judgment is rendered in session case number 289 of 2015. The application under 319 was filed in this session's case. Now, just kindly take page 9 of this judgment. I just want to show your lordships. It records that the para in the lower half of the page, after completing necessary formalities, challan was presented against 10 accused by mentioning that investigation is pending against the remaining person. And after completion of investigation, challan against them will also be presented. So there was only one more accused original. So there is his challan is much later. It comes in 2019. So therefore, there is no trial or inquiry pending against him. Then kindly have page 84, where this application is mentioned. Page 84. What he says in this judgment at page 84. Para and bottom of the page. Learned APP further argued that during investigation it is transpired that kingpin behind the whole sequence was Sukhpal Singh Khera, who through his personal security officers Joga Singh and Manish and Charanjit Kaur were behind the curtain, argued that summoning these accused an application under 319 has been filed, which is pending for today. Then he records in brackets, application for summoning accused is also filed, which is separately registered as criminal miscellaneous because High Court has directed to dispose of this case. And which application this court is going to decide today itself by separate order. Now, this is absolutely incorrect. He has no inherent power of like a 482 or a 151 CPC. He is bound by the.
So this makes it clear that he has decided it after the.
Correct.
The judgment is pronounced.
Correct. That the second order also says that today I have already pronounced my judgment. That order will also say that. So therefore, now kindly have that order by which the application is decided, because that application is not being decided in this session trial at all. It is a separately numbered criminal miscellaneous. How is it even maintainable? Is the question, is the first submission, my lord. Just kindly see that order, my lord. That is at page 121 in the main paper book itself.
Page?
Page 121 of the SLP paper, the first paper. (121). Kindly see the top. Criminal miscellaneous number 339 of 2017, filing ID CNR, the trial number is missing. It was session case 289 of 15. So he's not deciding it in that session case at all. Because according to him, he's made it a separate standalone application today. This order is completely against law on this ground alone. Then he records this order of mine will dispose of an application, etc. On facts, I'm not going into it. Then he says at page 128, sorry, 130. As things stand out, this FIR was registered and challan against 10 accused was presented by mentioning that after investigation, the challan against the remaining accused will also be filed. Till date, no challan is presented against the accused whose names are mentioned. By my separate judgment, all accused against whom challan was presented, except one, are convicted today. Then proceeding was separated because High Court said decide quickly, etc. So therefore, he also records that I have already decided that. So, my lord, so therefore, my lord, the submission is that this order is completely against law. It is completely illegal because he himself separates it from the trial. Now, where is his power to separate? That is 317. Kindly have 317. When can he separate? 3172. And which trial he can separate? It is only against an accused against whom an inquiry or trial is pending. 317, the title is Provision for Inquiry and Trial being held. I'm sorry. Not this, provides. 317.
Yes.
Or 317 says provision for inquiry and trial being held in the absence of the accused in certain cases. One is not relevant, but for the sake of completedness, I will read it. At any stage of an inquiry or trial under this code, if the judge or magistrate is satisfied for reasons to be recorded that the